Does this work? Yes. Huh? Okay. Good afternoon, everybody. Thank you for inviting me here to give the opening address to talk a little bit about GDPR, a subject which is, I think, top of mind for many people, especially those in the room today, otherwise you would not have been here. I will try to give an overview of how we are tackling now in Belgium the implementation of GDPR, which actions we are taking, but also a little bit how we look upon how the GDPR will unfold over the next couple of months, and of course also after May 2018 when GDPR comes into force. We all know that we are living in a rapidly changing world where digitalization is really progressing at a very rapid speed, and I think there's no sector anymore which escapes this digitalization and this, let's say, innovation in order to really assess what's going on within your organization. And so I think that the GDPR has to be seen also in the framework of an open European market, enabling also the free flow of information and data, but in such a way, of course, that the privacy and the rights of subjects and of consumers is guaranteed and protected. And this digital economy is really advancing at a very rapid pace. You see here the number of unicorns, Unicorn Club, companies worth over €1 billion. Well, you see that the pace on which these companies are developing is really, really increasing, and there is yet more to come over the next couple of months and years. So the digital economy is really here. And this puts fear in some people. I've had many discussions also in this building with some sectors which say, look, digitalization is really costing us jobs, it's going to hurt the economy. In my opinion, the contrary is true. There's a LISBON Council, which is one of the main think tanks at the European level, who did a study and a survey which concluded that for every 2 jobs which disappear in the classical sectors, 5 new jobs will be created in a digital economy. This, of course, will be different jobs. This means that you will have to reschool, retrain your own staff internally, or hire new staff to go into new business models and new business sectors. So it requires a lot of effort also from the companies, but on the other hand, it also creates tremendous opportunities, not only for the companies, but also, I think, for the economy in general. And with this new digital economy, which is advancing, you also see that the concept of privacy as such is changing. Where privacy used to be seen only as a fundamental human right and more or less a protection against mainly the state or others not infringing on your rights, you see now that it has also evolved the concept of privacy into data protection, the protection of personal data against improper use by third parties. And so those 2 elements which define a modern concept of privacy, I would say today, is also at the core of finding a new balance. Finding a new balance between creating opportunities for companies, but also giving back control to people on their data, and making sure that they're able to choose freely and in an informed way how they use their own personal data. But at the same time also, we know that these new data sets create tremendous opportunities for entrepreneurs and companies, but I think we have to find a new balance between those 2 elements. And so this also is at the core on how we look upon privacy and data protection in general. And of course, the conclusion, the latest culmination of this new balance was found in the new European regulation, the GDPR, the General Data Provision Regulation, which clearly defines who, what, and why data can be used. And what is tried in this regulation is indeed to find that balance between giving clear rights to data subjects and clear obligations to those who are handling and using data, but also increasing transparency and increasing also the legal stability in which companies can act on these new opportunities. And so the main principles, of course, of the GDPR, you all know them, where the GDPR clearly defines principles for data processing, obligations for the processes, but also the rights of data subjects, which are all clearly defined. The first question I always or usually get when I talk to organizations or companies or even government organizations when it comes to GDPR is, what are the fines, the sanctions? How is this going to work? And I will come back to that later, but I would like to say also already here that the sanctions for me is something at the end of the line. For me, the main driver in the GDPR is the fact that each organization, each company, each government organization should really use GDPR and the principles put forward in GDPR to really take a good look on how data is handled, stored, how data is flowing, how data is used in your own organization, and that this opportunity clearly exceeds also the cost that maybe GDPR implies when it comes to just compliance. So I also see this as an opportunity, and of course if you seize the opportunity in a good way, then you can also forget about the sanctions. What is also important, and one of the main principles which is put forward in the GDPR, is clearly consent. Informed, freely given, and very specific consent on how your data is going to be used. And this is also the key driver that should really put forward the thinking in your own organization. How can I obtain and how can I get the trust of a consumer to give this consent in order to use the data for the purposes that I want to do in my company? The GDPR also clearly defines the subjects, the rights that data subjects have when it goes to look-throughs, correcting information, deleting and erasing information, but also transferring information. And that's also a very important topic. The data set that you have about certain people, once these people, and they should be informed about it so they know that you have these data, can also be asked and then taken away from you much easier than before. So also there your organization should be fit to do this. It puts a lot of obligations on the data processor or the controller, yes. The organization should really think about privacy by design and privacy by default. It should also have a clear register of data processing activities. This is also something that's really important, again related to your obviously first question, how to avoid fines. Well, monitor and register. This is really important that you can show what actions you have taken to prevent possible infringements on GDPR. If there is an infringement or a data breach, then indeed there is a clear reporting obligation on the organization. And also the discussion that was mentioned already in the introduction, when, for example, a DPO is going to be needed, is also clearly stated in GDPR or within the guidelines provided by the Working Party 29. Compliance with GDPR basically consists of 6 big tasks. The first of course, that you need to consider: what is your country of establishment? Where will your company reside, and which will be the primary spokesperson when it comes to who you're talking to on the Data Protection Authority? So you also need to go through an exercise who is going to be responsible internally. This cannot just be an exercise where you appoint a lawyer or you import your IT manager. It is really something in GDPR that should be instated throughout your organization. So it's not something where you can just say, this is the guy who is responsible for compliance. It really needs to go through the whole organization. And so also there, again, the guiding principle is you need to get informed consent before any data can be used. What is really important, and also an opportunity in my opinion, is the fact that you have really now the chance to go through your data and try to understand and know your own data that you already have. Based on that assessment, a lot of other principles follow. For example, if you know that your data is highly sensitive, that you collect a lot of data about your clients, then automatically it follows that you need a DPO. Under certain circumstances, when you have a limited data set with limited information on just occasionally, then you don't need a DPO. So all these elements, knowing your data, a lot of other elements follow from that. It's also really important to understand that you try to monitor and register what you're doing to comply with the rules of GDPR. And like I said, because it's something that goes throughout your organization, it's mostly for those organizations which are a little bit more elaborate to also foresee training programs initially, but also monitoring auditing programs in order to make sure that you stay compliant with GDPR. For international companies, how are you going to organize your international data transfers? Also there, the informed information towards your data subject is really important, but also the fact that the data transfer takes place under the right conditions. Privacy by design and by default are guiding principles, but of course you need to determine in your organization how you're going to do this, how specifically you want to build this into your system. Data minimization is something that's often overlooked, and it's a little bit contrary maybe to what is ongoing right now when it comes to big data. But also there, the bigger your data set and the less you know it, the more liabilities you have, maybe known or unknown, when in not complying with the GDPR. So also safety and cybersecurity come into play when you discuss GDPR. Clear internal policies, making sure that you have clear contracts with all your contract salesmen, sister companies, making sure that everybody follows the same guidelines and rules within GDPR. But also the fact that you need to prepare for data breaches. Everybody tells me, all cybersecurity experts, it's not a matter of when, it's a matter of how and where you will be confronted with a data breach. Everybody will have the situation at one time or another. whether it will be from an external situation where somebody is trying to hack into your company, or an internal misuse of data, or somebody who's being negligent. So also there you really need to make sure that you are prepared and you have the right procedures in place. But also this helps you to install trust with your consumers, with your clients, in order if you have these kind of elements in place. And of course, the end point of this all, in the end, will be the Data Protection Authority. The Data Protection Authority will be the authority in order to make sure that there is compliance with the rules. Just to be very clear, my role as a State Secretary consists of doing the reform of this Privacy Commission in Belgium into a Data Protection Authority with new competences, with new people, with new elements in there in order to make sure that they have all the tools in place to do on the terrain the check of the GDPR in organizations and companies. But the Data Protection Authority will be an independent authority. They will be the ones responsible for issuing guidelines on how certain elements of the GDPR should be implemented. For example, when we look at sectoral guidelines, it will be the DPA who will be the one responsible for making sure that they are compliant with GDPR. It will not be me. A second point that I will do is, of course, and this is maybe a little bit strange for the legal people amongst you, although the GDPR is a regulation and has direct effect from May 2018, there are some elements in there which have an impact and that we as a member state still have to decide. So I will also make sure that those elements are being implemented in a general new privacy law, replacing the law of 1992, and making sure also there that we make clear choices on how data flows and GDPR principles will be implemented, for example, within the government, but also, for example, how broad the research exemption will be in Belgium. So these choices we still have to make, and probably a first draft of that proposal will be made in September. When it comes to the reform of the Data Protection Authority, of the current Privacy Commission, we already passed through the system and we had an approval in first reading by the government. It's currently on the revision by the legal authorities, and we expect that to come back in the next couple of days or weeks, and hopefully before the summer we can still have a second reading within the government, and then of course the reform of the DPA is concluded and can start. The main tasks of this Data Protection Authority will clearly be that they have to certify or help to certify DPOs, not directly, but through, again, issuing guidelines and collaborations with other organizations. It will have to provide guidelines for processes, like I already explained. This is going to be one of their main tasks over the next 12 months. And also making sure that these codes of conduct and guidelines are being discussed with the different sectors. So what the main task of the new DPA will be over the next 12 months will clearly be creating legal certainty, explaining to companies, to organizations, to sectors how GDPR should be implemented. That is their main task. And what you have today is that we have reformed it in order to prepare them also to fulfill the tasks after May 2018. This is the current Privacy Commission. You see also all the different sectoral committees, which today provide authorizations for data flows within government and between government and private sector. This is the new one. Again, the old one, the new one. It's much more elegant, I think, not only on paper, but also on the tasks that it will have to perform. We will still have a general secretariat where, for example, policy advice, guidance. There will be also an ombudsman where the questions or certain complaints can be launched. What we specifically did is that we created a knowledge center. The knowledge center really is there to assess all new technological things that come onto the market and say, okay, what impact does this have on privacy? What impact does this have on how we see privacy? What impact do we need, or what tools do we need to develop in order to make sure that these new technologies are also in line with GDPR? So that's the first element that we introduced, and it's new. A second one is that we also introduced an advisory chamber. We took this from the Netherlands, where there's an advisory chamber with people from different sectors, mainly from the private sector, really issuing guidance to the Privacy Commission, to the DPA, saying, okay, we think that there are certain sectors where there's a higher risk of non-compliance with GDPR. Maybe you should take a look there first. And they will issue this kind of guidance and give this kind of more, let's say, long-term vision on how and where the priority should be of the DPA. In the end, the DPA is independent. They can still do whatever they want. But in the end, it's also important that this kind of input can be given because, of course, the budget is not unlimited. So we have to have priorities. And this advisory chamber will help, I think, to formulate priorities. And I think it's also important then that to the private sector this can be communicated and that afterwards also when these checks are being done, For example, you could say that we are going to take a look into the insurance companies which are active in the health sector. We will do some audits in these companies. In the end, there will be a white paper issuing guidelines for a whole sector. And I think in that way, we will be able to bring into more compliance into the GDPR the different sectors. Not going by company, that will take too much time and too much resources, but really having also this sectoral approach. Yes, the DPA will also have teeth. They will have an inspection, performing inspections on site. Also there, it's a new tool that they have. And ultimately, there will also be a litigation chamber which can issue sanctions. The main driver in this process is an escalation mechanism. Whenever there's something detected which is not in compliance with GDPR, there will be, of course, first a discussion, a dialogue saying, okay, how come, what do you need to change, can you implement change? If this is done by the organization, then I think the complaint can disappear. If there's really a true company which is not following the GDPR consistently, then of course ultimately this can lead to fines. So these fines are really a stick behind the door, and we're really going to try to make sure that there is a procedure in place where the main driver is compliance with GDPR. The GDPR is not there to fill the coffers of the state. The GDPR is there to instill compliance, good use of personal data, and having also the certainty that people's privacy is respected and how their data is being treated in a correct way in compliance with the GDPR. That is the essence of how the reform is being construed. And so what we're also doing is having a constant dialogue also at the international level, because what I sketched out is of course how we're going to do it in Belgium, the philosophy that the Belgian authorities will have. But of course we are still functioning in a European context. It is in my opinion, if I can speak freely, again, something very strange. We all consider privacy to be a fundamental right. We all consider privacy to be crucial in data, being able to have data flows across the internal market, across the 28 member states. But the controls on how this is being done is still instilled in member states, which is as such a very strange thing. But it is a decision after discussion between the Parliament, the European Commission and the different member states. It is done like this. So we have to collaborate with the 28 other regulators. So in that respect, we still try to push as much as possible at the European level to have guidelines, guidance, codes of conduct which are provided at the European level in order to keep also consistency there. It doesn't make sense that, again, we see fragmentation after the GDPR starts in May 2018. What we're also trying to do is to instill this legal certainty, to have really a code of conduct which can be validated by the DPA. So it's also a call to all of you to start discussing within your different sector and sector federations to maybe come up with this kind of codes of conduct and have them validated by the DPA in order to have also legal certainty on how you can go through and go forward with the implementation of GDPR in your organization. And of course, the DPO and the privacy impact assessment also provide new opportunities. Really, it is an incentive for me to really look at your own data flows within the companies to try to do better with the data that you have, not only when it comes to protection, but if you know your data better, you're also better placed to use it afterwards for new applications, for example. So this is really an exercise where every organization should go through, and you still have 1 year to do it before the GDPR enters force. So it also creates new IT opportunities, and it also creates the fact that the DPA, like I sketched out in the escalation mechanism, will also have a coaching role. So initially, this will also have to go through as how are we going to do things together, how are we going to implement this GDPR, and how is this going to be done. But of course, the DPA will have teeth to also make sure that those companies who are doing this investment, who are doing this exercise in a decent way, that they also receive fair competition, that they don't see competitors running around making a mockery out of privacy. Those companies will be tackled also by the DPA. So in the end, the DPA will play a really, really crucial role with protecting, of course, fundamental rights, but also trying to stay ahead of everybody in at the European level and creating legal certainty, but also opportunities for citizens and companies alike. But in the end, they will also have strong teeth in order to make sure that when necessary, they can bite. Thank you for your attention. This is a very quick overview, but I think that the next speakers will have much more to tell on how concretely the GDPR can be implemented in your organizations. If there are any questions, please feel free. Thank you.
When you mentioned the teeth of the DPA, you only mentioned the fines as a sanction. However, Article 58 even allows a temporary or definitive limitation, including a ban on processing activities, which means that the DPA could even tell a non-compliant marketing company to no longer do marketing activities. How come that is really mentioned as a sanction anywhere?
Well, it is provided in the escalation mechanism. So also there you will see that at that moment the DPA, which is an independent body, has the choice, according to what you just sketched out in the different articles in GDPR, to make sure that companies are becoming compliant. And for example, they can stop allowing data processing until the company shows that it is in order with GDPR, for example. So those are all measures. That's what I meant by making sure that in the end, the driver of this all is making sure that companies are compliant. The tools that are being used is at the disposal of the DPA. So it can be just, let's say, a friendly email saying, we think that you're not in compliance, please adjust. Up to the stage where they say, look, we will open a public inquiry into your company, up to a public statement saying this company can no longer, is no longer able to process data, or it can be done behind the scenes. And ultimately, the last element is, of course, a sanction. So all these elements are at the disposal of the DPA in order that it can make sure that companies and organizations are compliant with the GDPR.
I was very interested to hear about the advisory chamber of the DPA. You said it would be formed by different actors in the private sector. How are the interests and how are the points of view of the actual consumers or data subjects being represented?
Because we will, of course, in that committee, like in the Netherlands, there will different people will be with different backgrounds will be represented there. And of course, one of the main elements is, of course, in the end, the whole GDPR is there in order to safeguard the rights of consumers and data subjects. So they will be automatically also represented in that kind of committee. The second element there is, of course, that it will not be a body like maybe in typical Belgian tradition where all the sectors will be represented. That's not the idea. It's not a paritaire comité, like they say. It will be much more than that. So it will be specialists coming from different backgrounds who will be able to really provide guidance for the, let's say, a little bit more longer term on which sectors are of interest, specific interest for the DPA to go and check out.
But it will not be like the private sector representation.
No. It will not be. It will not be again the usual suspects who say, "Now I need somebody around the table." It will be people. It will be people who will be around the table based on an expertise, not a membership of an organization.
I think languages are very sensitive for people in Belgium.
For some, yes.
For some people. Working for an international organization, we mostly work in English because we work with also do compliance at a global level. And I wonder whether it would be a requirement to have the data registry or data mapping and all the documentation that we need to show to the authorities, groups that are compliant. Do they have to be all in Dutch or French, depending where we're based? Can they be in English?
Today, it is already the case that some filings happen in English, especially for multinational companies. So I think that, as such, the current practice already allows it. So I don't think that we need additional legal safeguards. In the end, of course, what is the case is when you start communicating directly with data subjects, then of course the language issue pops up in the sense that you need to communicate with people in the language that they want. But as such, the communication with the DPA, let's say behind the scenes, I think there the working language for many companies and organizations is already English today.
And so the DPO could be somebody who doesn't need to be somebody who's fluent in Dutch, French, and English, for example.
Well, the question then becomes, of course, the role of the DPA. If the DPO, if the DPO needs to communicate, the role of the DPO is very well defined. It needs to be somebody who's independent. It needs to be somebody who has knowledge both of legal and IT. It's somebody who's close to management. It's somebody who's able to communicate also internally into the organization. So it depends on the organization. If you have, let's say, a multinational company where the working language is English, okay. But if you have a smaller company which is processing a lot of data with high sensitivity, then of course the DPO needs to understand how to communicate these sensitivities and these processes and guidelines also in the organization. So it's more, I think, an organizational driven element.
As part of the GDPR, there is a right to be forgotten and maybe worse, right to be erased. How about statement on backup and archiving?
Yeah, there are two elements there. One is that the right to be forgotten or the right to be erased, whatever you want to call it, sometimes conflicts with general interest, other regulations, other directives. So we're currently trying to detect where it poses a conflict. It's not only about the right to be forgotten, it's sometimes also about data retention, for example. So a maximum of 5 years in one regulation, 10 years in the other. So we're trying to find out now how all these elements fit together. That's one part of the answer. The second part of the answer is that there is clearly foreseen in GDPR, for example, when it comes to archives and things like that. We have a discussion, for example, with the Belgian National Archives, how they should handle this. There is a clear exemption there, and it will also be implemented in the framework law that we're doing in September. And the last part, of course, is we also have the technical committee to making sure what exactly constitutes the right to be forgotten or the right to be erased. Do you really have to erase everything, or is there allowed to keep tracking that this person was at a certain moment in time a part of your database? So all these elements will also be cleared by, and this is a guideline I think that also the DPA should start to give. Like I said, we try to push for guidelines at the European level as much as possible, because we want to keep intact this internal market. But if these guidelines are not coming from Europe, yeah, then we have to start issuing guidelines ourselves. But that is a role of DPA, that's not my role, because it is clear that with the implementation and the specifications in the GDPR, there the DPA has to take responsibility on to say, you can do it like this and then it's okay, you cannot do it like this because then there will be a problem.
We have time for one last question.
Is it possible to already ask questions to the DPA?
Yes.
How can
You just did.
No, so you can contact the DPA, and I must say that the DPA is today already doing an extraordinary effort in trying to have contact with companies and trying to reply to questions. I think we have to take the next step. Under Article 40, it is very clearly defined that they can, for example, per sector, the sector can propose itself codes of conduct, and that can form a basis of discussion with the DPA, for example. That for me is the most interesting route, but there's also the possibility to contact the DPA directly and to have a discussion with them and an engagement with them how we should do certain things and how certain elements of the GDPR should be implemented. But it is up to the DPA to decide whether or not it is in a position to answer.
Thank you, Mr. De Backer,
Thank you
for this clear overview.